Yep. All right, great. Welcome all. Thanks for joining us. The committee's received submission from the Australian Commission for Law Enforcement Integrity as number 11. Do you wish to make any amendments or alterations to your submission?
No, thank you, Senator.
Thank you. So for the Hansard record, and we are organising some additional nameplates for you, but for the Hansard record, would you each please state your full name and the capacity in which you appear this morning?
Philip Moss, Integrity Commissioner.
Good morning, I'm Nick Sellers. I'm the Acting Executive Director, Secretariat.
Sarah Marshall, Acting Executive Director, Operations.
Sarah Baker-Goldsmith, Principal Lawyer.
Thank you. So the Senate's resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and should be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy. It does not preclude questions asking for explanations of policies or factual questions about when and how these policies were adopted. Officers of the department are also reminded that any claim that it would be contrary to the public interest to answer a question must be made by a minister and should be accompanied by a statement setting out the basis for that claim. Do you wish to make a brief opening statement before we go to questions?
Yes, I would please, Senator.
Mr Moss,
Thank you.
The floor is yours.
Thank you. ACLE's primary role is to investigate law enforcement-related corruption issues, giving priority to serious and systemic corruption. ACLE's jurisdiction reflects the high-risk nature of law enforcement, which brings officials into the proximity of serious and organised crime and offers corruption opportunities. 6 agencies are presently subject to the Integrity Commissioner's jurisdiction, namely the Australian Crime Commission, the Australian Customs and Border Protection Service, the Australian Federal Police, the Australian Transaction Reports and Analysis Centre, known also as AUSTRAC, the CrimTrack Agency, and prescribed aspects of the Department of Agriculture. Telecommunications interception and access is a critical capability for the investigation of serious corruption, since it captures direct evidence of offences and advances investigations in an efficient way. For instance, telecommunications interception and data access was essential in Operation Heritage, an investigation into corrupt conduct by Customs and Border Protection officers at Sydney International Airport. Operation Heritage is an investigation undertaken jointly with the AFP through its Operation Marker and with assistance from Customs and Border Protection. The investigation, which is now in its 3rd year, has resulted in the arrest of 23 individuals, including 5 Customs officers and 1 from the Department of Agriculture, and the dismantling of a criminal network. The investigation would not have been possible without telecommunications interception and access. I would like to emphasise the importance of access to data at the preliminary stages of an investigation. Investigations such as Operation Heritage seek to uncover the full extent of a corrupt network, but often start with only snippets of information or credible allegations. Data about a person of interest Data about who a person of interest is talking to is often a critical first step that provides a foundation for further investigation, including, at a much later stage, seeking a warrant for interception. It also allows us to rule out, at an early stage, people who are unlikely to be complicit, thereby preventing the need for unnecessary investigation and deeper intrusion of privacy. The fundamental principles underlying the TIA Act are sound, namely that lawful access should be permitted in limited circumstances with corresponding safeguards and accountability measures that recognise the importance of privacy protections. However, a number of submissions to the committee have expressed the view that there is a need to reform the TIA Act to ensure that it reflects the current telecommunications environment, which has changed significantly over the last 35 years. I agree with that view. I note also that law enforcement practice has changed dramatically over the same period. In contrast, the TIA Act does not contemplate agencies working together. In the modern era, which is characterised by agencies working closely across the Commonwealth, the legislative barriers to sharing TI information are time-consuming, unnecessarily wasteful and bureaucratic to navigate. The resources involved in administration could be better used to strengthen internal accountability arrangements. While existing powers and capabilities have proven valuable, my view is that a number of reforms to the existing regime are desirable in order to provide anti-corruption agencies with appropriate means to uncover and respond to corrupt conduct. ACLE's submission has outlined a number of the areas where I considered there is scope to improve the operation of the TIA Act. I welcome any questions that the committee may have on any of these issues or other matters on which I or my officers may provide relevant information. Thank you, Senator.
Thanks very much. Go to questions. Senator Seselja.
Sure. Thank you, Chair. Thank you for the opening statement. Yesterday we heard from the Crime Commission and they talked us through a little bit of some of the oversight that is there for the Crime Commission when it goes through processes for intercepting telecommunications and the like. Wondering whether you could briefly share for us your agency's, what particular oversight is there for the Commission for Law Enforcement Integrity when you undertake phone taps and other telecommunications interceptions?
Thank you. May I ask Sarah Baker-Goldsmith to answer that for you, Senator?
Senator, the internal arrangements ACLE have in relation to interception warrants are quite complex, and they're backed up also by the inspection capabilities of the Commonwealth Ombudsman, who regularly inspects post-fact the warrants that ACLE has obtained. The Integrity Commissioner has delegated certain officers within ACLE to apply for interception warrants on behalf of ACLE.
How many officers would have that delegation?
3.
Okay.
And those officers are sitting at the SES level and the executive level too, being the Directors of Investigation and Intelligence and also Executive Director of Operations. So if an investigator wishes to considers that an interception warrant would be an appropriate tool to use in a particular investigation, they must effectively put a submission up to the relevant director. And the Integrity Commissioner is also aware in a general sense through briefings of cases where interception warrants are considered to be considerations given to applying for them. The Director of Investigations or Intelligence will make an independent decision about whether or not it's appropriate for a warrant to be obtained in a particular circumstance, and then make that application to the appropriate issuing officer who in Canberra, we often go to members of the AAT and to federal, who used to be federal magistrates. I understand they're federal circuit court judges now.
Yes. So you've got your internal processes where you've got three delegates. The commissioner is broadly aware, and then there's the process of going through the warrant process if that's necessary.
That's so, Senator. And can I also add as well that throughout the process, the ACLE lawyers will also be involved in providing legal advice about the appropriateness of about the legal standards and thresholds that are required to be met.
Now, I'm sure it's somewhere in one of your annual reports and the like, but I don't have it in front of me. How often is this used? How often is this used by the Commission?
It's a tool that we are increasingly making use of. I think that the first warrants that ACLE applied for were in the 2010-2011 year, and we got 4 warrants in that year. In the current financial year to date, we've got 23 warrants. Okay,
so it's becoming more common. You talked about the Commonwealth Ombudsman having oversight. What's the nature of that? Does the Ombudsman come in and do spot checks, or what's the nature of that relationship?
The Ombudsman is generally aware of when we're seeking warrants. We have quite a good liaison relationship with the Ombudsman. The present arrangements are that they inspect us twice a year, and because of the comparatively small number of warrants that ACLE gets, they do a 100% check.
And they're checking for what? To see that it was appropriate in all the circumstances to seek a warrant? What are they checking? What criteria are they checking against?
They're checking against legislative compliance with the Crimes Act.
Okay. And what have they given you a clean bill of health in terms of those inspections? Yes.
They raise some issues of administrative best practice to improve the way that we keep our records, but I'm aware, so far as I'm aware, it's a clean sheet.
Okay, thank you.
I can confirm that in all cases the Ombudsman has found full compliance by ACLE with the TIA Act.
Okay, very good. Just briefly, we've had other submissions in relation to mandatory data retention. And one of the submissions said that it would create a honeypot for hackers, I think was the terminology used. Can I get you to respond to that? You obviously don't agree with that, but why is that not a legitimate concern, that if there's mandatory data retention, that there would then be the ability for someone to mine that data, which obviously raises further privacy issues?
I'll ask Mr Sellers to address that question, please, Senator.
Senator, in many senses, that's a question for the telecommunications industry and about the security standards they apply. So far as ACLI is concerned, there are investigative advantages for us if data is retained. For instance, it's difficult to determine when data is no longer required. So I think some other witnesses, the ACC, have mentioned a 2-year data retention period would be a reasonable compromise. Just want to draw to your attention that at one stage in a recent ACLI investigation, we discounted an individual during the investigative process, and 6 months later, through further investigation, that individual re-emerged as a key member of the corrupt network we were investigating. If the data had been destroyed, and as it happened, we had already captured the data, so it wasn't an issue in this instance. But had we needed to go to a service provider and that data was no longer available, we wouldn't have been able to achieve the number of arrests we were able to in Operation Heritage. So it does have a practical application. I acknowledge those witnesses who are concerned about the honeypot problem, and it's an issue that does need attention. There's no question about that. It's a matter of finding what can be achieved in this space.
Sure. So, in your opinion, it's not a reason not to do it. It's just a reason to make sure that if you do it, your security measures are as strong as they can possibly be.
That's right, and our understanding is quite a number of providers already retain data as part of their normal business practices. I'm not in a position to give you the, who does what, but it's been common practice for a long time. But there's variability between agencies.
Senator, in that case mentioned by Mr Sellers, where we discounted the relevance of a particular customs office in relation to our investigation, then came back some 6 months later, that officer was subsequently sentenced to 7 years in jail for abuse of office and involvement in importation of drugs. I just want to emphasise the point, but for the availability of that data, and if it had been destroyed, that outcome would not have been possible.
I think the other thing, if I may, Integrity Commissioner, is these investigations are very complex. That case whereby someone is able to fly under the radar, they know how to avoid detection largely. And this is why law enforcement agencies, if I may say so, bang on about data retention, because often you have to go back to the historical record when people weren't being quite as careful. The more a corrupt network or an organised crime network gains in sophistication, they're more careful, and it's the historical record that frequently becomes of more value to law enforcement agencies. Yeah. So I hope that explanation helps you understand why we think it matters.
No, it does. Thank you very much.
I might carry on in similar vein, if I may. When Senator Seselja posed the question to you about the honeypot effect, you said, the security's a question for the telcos. Some of them really don't want it. We'll hear from IINet later in our... Later in the evidence that we take, they're very, very critical of this proposal because they don't want that security responsibility. So as one of the agencies demanding it, and the alignment of agencies and arguments that are coming forward for data retention is very, very consistent, it's actually not going to be good enough to fob that back off to the telcos, who in some cases don't want to have to contain this material at all. So what's your response to that?
Well, Senator, I couldn't agree with you more. I think the role of law enforcement agencies is to say to the Parliament, this is why we think it would be valuable, this is why we think it matters. But public policy, good public policy is always a matter of finding balances and accommodations to get the right public policy outcome. I can't advise I'm not in a position to advise the telcos on how they can run their data security, but we're just saying we need to look for ways that this can be achieved.
Sure. Mr Sellers, do you have a commercial mobile phone provider?
Yes, I do.
You do. Would you be concerned about your material being archived? Same with everybody else, criminals, ordinary people, High Court judges, anti-corruption officials?
Oh, look, I'm not sure as a public official that's a question I can properly answer.
Maybe as the one who read in that you don't have to give opinions, probably a little bit naughty for me to then ask you one. But do you understand the point that I'm making is that you're creating a very, very large database of everybody's movements and materials, phone contacts, social networks, from top to bottom of Australian society. Now, you will be able to mine that quite effectively for the extremely important work that you do, and other people may well be able to access that material as well for very different purposes. That's a security issue, I would have thought.
Yes, and I think the point I can answer on is it's the point of the Telecommunications and Interception Act is to regulate when government officials, law enforcement officials, are able to gain lawful access to that material.
Yeah.
And that's what our interest is.
Indeed. And so we have to bear regard to that because of the importance of the work that you do. Of course. And I don't think anybody on this committee is in any doubt of that. But the global tech community is reeling from revelations of a very, very deep security flaw in server architecture that's almost ubiquitous. It's right through the internet that has leaked unknown amounts of private and personal information. Do we really want to create this huge store of everybody's material? Because you're asking for 2 years now, others mentioned 5 yesterday. I think eventually it will be in perpetuity if we let this get away. Do you recognise the security issues that are at stake here if this tool is created?
I think I've answered that question, Senator, yes.
Okay.
Senator, it's an interesting point you raise and a very vexed one, if I may say so. I worked in the first Human Rights Commission chaired by Dame Roma Mitchell,
right,
and conversant with some of the human rights issues that you have raised, both in public statements and articles that I've read. But in my present perspective, the scourge of corrupt conduct can't be discounted.
I'm not trying to discount that.
And the question of finding some balance here between these two important considerations, I think, is what we're striving to do.
The instance that you gave us before about the one who nearly got away, that you ended up prosecuting and was in prison for 7 years, it sounds as though you almost got lucky and that you had some material that you'd stored yourself. Was that the example that you gave, Mr Sellers? You happened to have a record that you went into.
So the individual was a person of interest at the beginning of the investigation,
yeah,
and so some data was collected as part of that initial step. And since the investigation was ongoing, that material was kept and still available to us.
All right. So what's your process for targeted data retention? If you have a person of interest, are you able to say to a telco, these 5 people are persons of interest, can you, for the time being, trap and store, like a very selective, narrow data retention model? What's the framework for doing that for suspects?
The Act does provide for preservation notices.
Yeah.
But those preservation notices have to be followed up by either a warrant or an authorisation to disclose at a later date. You can't just put a preservation notice on indefinitely.
No, that's fair enough. That's within the TIA Act, or is it somewhere else?
I think it's the TIA Act, I'm pretty sure, if I can have a moment.
And could you put a preservation notice down on an entire town, or is it narrower, like your particular staffing cohort, or? And how often do you use those? Because I guess that's a very narrow form of data retention, isn't it?
Yes.
You're not necessarily even going to see the material. You might decide later you don't need it.
You just consult the legislation, Senator.
Thank you.
My feeling is that you couldn't get one for an entire town. I'm pretty confident that's not the case.
But you could get this particular staff cohort for an airport in one of the examples you were using before.
While Ms
Thanks.
Baker Goldsmith consults the enactment, ACLE's investigations tend to be very targeted. You've heard from the Commissioner about his human rights and privacy concerns. That culture permeates ACLE, and as a result, our investigations are highly targeted, and it's one of the reasons why data access is useful to us in the beginning, as the Integrity Commissioner explained. It helps us narrow our investigations as soon as possible. The Commission has a number of intrusive powers, including coercive powers, and we need to be very careful in how we administer those powers. So it's something we're mindful of, Senator.
Is there any requirement? We've got it, by the way, Ms Baker Goldsmith,
Yes.
if you found it too, is Division 2, 107H and on.
Yes, that's where
Yeah,
I'm at, Senator.
Thank goodness for the committee secretary. So we'll take a look at that. Is there any requirement on ACLE to destroy telecommunications data once it's been obtained? The ACC vote yesterday couldn't think of a reason why
I
they
don't
needed to.
believe so.
Okay. Senator Xenophon, I might throw to you and then I'll come back if there's time. But
Sure.
thanks for your help.
I note that your submission to the inquiry into potential reforms of national security legislation back in August 2012 made reference that public officials who work in law enforcement context present a particular corruption risk, and part of that risk would be that they have particular knowledge as to how their agencies operate in terms of their own surveillance. I mean, what do you do with? I mean, you can buy an encrypted phone, can't you? I think you can buy them for about $1,500 or $1,600. I don't have one, but what I want to know is if a group of corrupt officials had half a brain, they wouldn't communicate by email. They'd use encrypted phones. How on earth would you, short of tapping, tapping their homes or the places where they congregate, how would you possibly get the evidence that you need? I mean, I'm just wondering that because of your aren't your recent successes the seeds of your own potential, not failure, but difficulties in getting further prosecutions, because they just won't use the internet, they won't use regular mobiles, they'll just be much more careful.
There are quite a few points there, Senator, if I may address that proposition you're putting in the question inherent in it. Firstly, law enforcement officers do understand the methodologies that we use to capture evidence in an integrity investigation. The point also is that at an early stage of investigations, it's of course covert. No one ever says to you, here's some corrupt conduct, please now look where we're pointing. So often we cast the net wide and have to bring the focus down as we start understanding the networks and who's contacting who and who's in relationship with whom.
Sorry, but my point, I'm sorry to interrupt, Mr. Moss, but my point is that if you have a group of individuals engaged, public officials engaged in corrupt conduct or planning to engage in corrupt conduct, and they know about your extensive powers for surveillance, which I don't have an issue with per se, in the context of trying to get those who are engaging in corrupt conduct, won't they just be much more careful and more clever in the way they conduct their corrupt activities?
Well, the point here is that we had actually talk about the corruption handshake, where corrupt officials work with criminals and organised crime, and that's at the point that you can either that you can come to full and useful application of telecommunication interception. In other words, you can either follow the criminals to the corrupt officials, or in some circumstances you can follow the corrupt officials to the criminals, because it is a question of their working together. And ACLE is increasingly reporting on the growing pressure, or the considerable pressure on border agencies, for instance, in this country from organised crime. So yes, if you're talking neatly of just corruption occurring by officials alone, particularly say law enforcement officials, then indeed it would be hard to use TI alone. But the point I'm making is that the relationship between criminals and law enforcement officials. That's our focus. So it's that both sides of the coin where TI is so useful.
I understand that, but in terms of a practical issue, and that is the use of encrypted phones, there is no law preventing encrypted phones being purchased in this country, is that right?
Yes. Look, I'd like to ask Sarah Marshall to engage, and then I'll ask Mr Sellers, because I think we're coming to the point of your
But my
question.
direct question is, can anyone... There is no law against buying an encrypted phone, correct?
No,
that's
there's
Right.
not.
And if someone has an encrypted phone, by virtue of the technology, it is impossible or virtually impossible to intercept that telecommunication.
Yes, the question is you may well miss out. But you don't use methods unilaterally. You use it in combination. So it might be a question of physical surveillance or other kinds of surveillance, or it might be a question of coercive hearing. All these things can be combined to overcome, say, measures put in place.
Can I just ask about, and you may not, if you're constrained in answering, I understand, but do you know if someone is using an encrypted phone? Per se, you don't, do you?
Sarah, can you answer that, please?
You don't know per se, but in an investigation there can be strong indicators that that is probably what a person is doing, looking at a bigger picture in an investigation.
So if you establish that an encrypted phone is being used, that itself would indicate a degree of suspicion. It would elevate the suspicion.
Correct.
Because people use many phones, and we might have a non-encrypted phone subject to interception, and then find out that certain conversations aren't occurring, or we're aware of events occurring that aren't being recorded over interception. So that might give you the clue that other means of...
Look, I won't labour the point, certainly the Chair wants to go back to some matters, but isn't the fundamental dilemma here, the more successful you become, the more cautious the criminals or the corrupt public officials will become? So how do you escalate it to then get the information you need to launch a successful prosecution?
Well, indeed, we've arrived at this conclusion ourselves, Senator, because in my last annual report I talked about corruption being harder to detect as people become more sophisticated and alert to, for instance, for those agencies at least in ACLE's jurisdiction, that ACLE is active and able to detect.
Senator, I think you've summarised the difficulty that law enforcement agencies, and particularly an integrity agency that deals with police, faces. The one thing we probably have in our favour is that these are risk takers, and there'll be a mistake somewhere along the line, and that's our way in.
My final question, and my interest in this goes back to the matter of Alan Kessing, the customs official that I believe was wrongly convicted under Section 70 and 79 of the Crimes Act for allegedly leaking material about issues of border, issues of corrupt behaviour within customs. Perversely, he was the one that got dragged through the courts and his life ruined. To what extent do you prioritise an investigation of an official if that official, pursuant to if it's a Section 70 and 79 matter, that is, that official is contacting a Member of Parliament directly with concerns of maladministration or improper practices within an agency? Is that something that you are concerned with, or are you concerned with corrupt behaviour such as smuggling of drugs or whatever? We're talking about if a whistleblower goes to a Member of Parliament, is that the sort of person that is a subject to your investigations, and which by extension would mean that the Member of Parliament would also be subject to surveillance?
I'm constantly being faced in the job of Integrity Commissioner of choosing priorities for work. And ACLE, as you know, is a small agency. It started in 2007 with 9 staff and now has 36 staff. And it is really a question of focusing on the highest order of the issues before me, which doesn't mean I discount the circumstances you're relating to me now. But in terms of some of the issues that I'm currently dealing with, they're the ones I'm giving priority to.
So you wouldn't give a priority to an official going to a Member of Parliament with concerns of corrupt behaviour within a particular agency? They wouldn't be the target of an investigation, or would you still investigate them because it would be technically a breach of Section 70 or 79 of the Crimes Act?
I just simply can't investigate all matters before me. I must prioritise them. And where I can't investigate them myself, then
Can you indicate
I refer them back to the agency.
Can you indicate without in any way identifying who the potential parties or the agency involved, whether your agency has undertaken surveillance in cases involving Section 70 or 79 of the Crimes Act in terms of communications between public officials and members of Parliament?
I don't believe we have. Can you confirm that?
Could you take that on notice,
Yes,
please?
certainly I will.
I'd be very grateful.
Yes,
thank you.
Okay. I might just finish up with the time that we've got left. In your submission, you note that ACLI does, I think you said there was around 20, you do undertake intercepts when cause demands it, but that you outsource it. I'm not sure that you use that word, but you don't have the resources yourself to do so. So you also identify, I think, top of page 4 of your submission, you say you recognise that there's the use of such shared services, i.e. that outsourcing may present some risks. The risk that jumps to my mind, obviously, would be if you're investigating the AFP, you can't then ask them to do your wiretaps for you. Is that what you're referring to, and how do you mitigate that?
Oh, it's a question of having a number of agencies who I can use to effect telecommunication interception, and in the case of an interception involving the AFP, then I would obviously not go there. I would go to the Australian Crime Commission or even to a state integrity agency if need be, to ensure that there was no compromise of an investigation by the capability I have in terms of telecommunications interception.
Okay. So, but I wasn't aware of that until you spelled it out in your submission, but each one of those intercepts that you have applied for is effectively one agency spying on another at your request.
It's the use of the provisions of the TI Act by one agency on behalf of ACLI, yes.
Yeah, okay. And what kind of risks do you believe are posed? What are you pointing us to there?
Do you want to talk about that?
Sorry, could you restate the question, please?
I'm just trying to work out what it is you're pointing us to. You recognise the use that shared service prevents some risks. So what are those risks and how do you mitigate them?
I think it's just to add to the Integrity Commissioner's point that we need to be careful of contamination of our own investigations. So we choose carefully which agency we go to for assistance.
Okay. And how much do those agencies know about what it is that you're after or that they're after? Are there kind of Chinese walls in place, or how much do you firewall the information?
So the modern way that this occurs, Senator, is the agency does the intercept, which is just a matter of a computer program that connects the material, and that gets piped through to ACLI, for instance, which is where the monitoring would occur. Sarah, did you want to add anything?
Yes, Senator. Within each of the intercepting areas of the agencies who we call upon for assistance, there are a limited number of people who deal with ACLI matters.
Okay.
So it's not as though the entire interception area knows this is an ACLI warrant. We deal with a few people who are authorised to know, and they are given as much information by us as they need to know for the purpose of effectively piping the information across to us.
Do you use exactly the same procedures for telecommunications data?
With data, we do our own authorisations.
Okay. All right. So they're not, I keep saying subcontracted even though it feels like completely the wrong word, but they're undertaken entirely by your staff.
We do our own data, telecommunications data authorisations, yes, and they come directly back to us.
Okay. So I don't know if it was the DG we had in front of us yesterday of the ACC said if we don't get data retention, we will be fighting crime with both hands tied behind our back, which I thought was a fairly serious thing to say. How important is data retention? 2 year mandatory data retention seems to be the number that's been landed on as a minimum. How important is that going forward to
It's absolutely important, Senator. I couldn't stress it highly enough myself.
What
and would
happens
be in full support of what the acting CEO of the ACC said.
And what happens if you don't get it? If, as you said, the job our job is to strike an appropriate balance. You have recognised that there are risks on the other side. What happens if you don't get it?
Well, I think from the integrity perspective, we are severely disadvantaged.
How are you disadvantaged now in ways that you weren't 5 years ago? You haven't had mandatory data retention up to now. Why is this suddenly such a burning imperative?
Well, it's just proven to be so useful and fruitful in investigations we've conducted so far and in recent years.
But we don't have it yet. We don't have it, and the only regime that I know of that does have it has just struck it down because of really serious privacy implications. So why is it such a burning imperative, both hands tied behind your back now, in a way that it wasn't a decade ago, for example?
Well, we can see the potential of it, and it has in fact, in actuality, been so important and useful to us.
But it doesn't exist yet. I'm sorry if I'm misunderstanding you.
Sir.
There's no mandatory data retention regime yet.
There's no mandatory data retention, but we do request data from the carriers who have various regimes for keeping it and keeping various, I suppose, types of data. We would have a lot of difficulty getting some investigations off the ground without that capability. So in the beginning stages of an investigation, access to data is essential to identify potential persons of interest or initial suspects in corruption investigations, to identify their associations, to look at possible lines of inquiry for investigations, to rule people in as persons of interest but also to rule them out, to discredit or credit allegations of corruption.
Now, I understand
and
how...
to formulate hypotheses
Yeah.
and ways forward.
I understand, thank you. I understand how you would propose to use it. It's more that it suddenly seems to have jumped to the very top of the list, both hands. Like, have you been operating with both hands tied behind your back up until the present time?
Senator, look, I would refer you back to one of your earlier questions to me about my personal mobile phone. The technology has changed. It's now ubiquitous. The way that mobile phones, for instance, and other forms of telecommunications are used now are very different to how they were used 5 years ago. There's also been changes in the way that law enforcement view this type of work. Law enforcement agencies are now weighting, WEIGHT, weighting towards intelligence-led investigations and skilling up in those areas. And I think that explains one of the big changes that's a driving force behind this request.
All right, thank you. Now, we're nearly out of time, so I don't know that you addressed it explicitly in your submission, but can I take it as read that you don't want to have to go to a warrant to get this telecommunications data? You think warrantless access for this retained material is sufficient?
Yes, that's my view, Senator. And of course, one precedes the other. It's this casting out to, in our understanding, to see who is the potential network of corrupt officials and what criminals they're working with. That's where the data is so important, and that, of course, then leads us to seek warrants as we then focus in from the broad to the more specific.
Which isn't to say there aren't improvements that could be made to that system.
What sort of improvements would you have in mind? Because that's partly what we're working on.
I think other witnesses before you have talked about inspections to ensure that the requests for data were appropriate in the circumstances and the least privacy intrusive means at the time. So those sorts of measures, but those questions are probably better directed towards the Attorney General's department. But we see that there are ways that there could be improvements.
Okay. All right, thank you very much all for your time this morning. Unless other senators have one last quick question? No. All right, we'll let you go.
Can I ask one on notice? In terms of the criteria, I mean, and you can take this on notice, how do you determine, what assessment processes that determine whether you're going to undertake a particular surveillance? In other words, what safeguards, what protections are there to determine whether you decide to go down a particular path? I think Mr Moss indicated that in relation to a Section 70 or 79 matter of communications between a public official and a Member of Parliament, that would be, I hope, way down on the list if it's a whistleblower type matter. If you could take on notice how do you, is there a matrix, is there a way that you work out why you do certain things in some cases and not in other cases?
We'll do that.
So I would just note that the Public Interest Disclosure Act now provides a lawful pathway for those types of communications. But as the Integrity Commissioner said, we'll take the rest of the question on notice.
All right. Thanks all. Very much appreciated.